Thank you, Your Honor. Before you today on State versus James R. Jones, file 25 CR 413. We're here today for a change of plea. It's anticipated by the state of Ohio that the defendant will withdraw his previously entered pleas of not guilty and enter pleas of guilty to counts 2 and count 3. And in exchange, the state of Ohio will ask this
The
court.
form says count 1 and count 3.
Yeah, I'm sorry. Yes, Your Honor. Count.
So what's he pleading to?
What's that, Your Honor?
What's he pleading to?
Count 1 and count 3.
All right, good.
I apologize. I'm reading off my thing here. In exchange, the state of Ohio will ask the court to dismiss the remaining counts at sentencing, other than a pre-sentence report and investigation, nor the threats or promises were made to this defendant to induce this plea. Thank you.
Thank you. Mr. Wolf, does that sound accurate?
Yes, Your Honor.
Thank you. And you can be seated at this point. Mr. Jones, I don't interpret that as any disrespect. It's easier to be sitting down when you're going through all this. So, all right, were you able to hear what was just said by the prosecutor regarding what they believe your intentions are here this morning, Mr. Jones?
Yes, sir.
It was indicated to court by the prosecutor. He believes it's your intention to withdraw your previous entered pleas of not guilty and plead guilty to counts 1 and 3. Counts 2 and 4 would get dismissed. We would defer sentencing to a later day to get some evaluations completed, come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations. Each side is free to recommend to this court whatever sentence they believe would be the right thing to do at the time of sentencing. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly what you want to do here today?
Yes, sir.
Well, before I can accept your plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with and pleading guilty to, all the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you a series of questions. If at any point when I'm asking you the questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to speak with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything we're doing here, all right?
Okay.
All right, good. Let's get started then. How old are you, sir?
I'm 37 years old.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
Yes, sir.
Now, before you came into court here this morning, have you had any drugs or alcohol of any kind?
No, sir.
What about within the last 48 hours?
No, sir.
Not even prescribed medication? Nothing?
Yeah, I can't think of the name of it, but it's for depression.
What's it for?
For depression.
Okay.
To help me sleep at night.
Anything else?
No, just that.
When did you last take that?
Last night.
Are you under the influence of that medication right now in any negative way, which is making it difficult for you to understand or appreciate your surroundings or what's going on around you?
No, sir.
Okay. So you've taken medication for depression?
Yes, sir.
That's it, okay. I added that to the form here, so that on this form that you previously read, and we'll talk about that in a little bit, it says you have not taken any drugs or alcohol in a 40-hour period preceding this hearing. I said except for medication for depression. Is that
Yes.
accurate?
Yes.
Okay. Now, you should have received, I know you did a copy of this indictment probably around the beginning of April, a couple months ago. Do you remember getting this document?
Yes, sir.
It sets forth what the charges are. You remember getting that?
Yes, sir.
You had a chance to review that at some point?
Yes.
Now, in that indictment, you are charged with 4 counts. You're pleading guilty to 2 of those. I'm going to go over those charges with you. If you have any questions, make sure you ask. But in count 1, what's alleged here, in count 1, what is alleged here is on or about December 10th, 2024 in Mentor Lake County, Ohio, that you did knowingly sell or offer to sell cocaine or some compound mixture, preparation, or substance containing cocaine. The amount involved did not equal or exceed 5 grams. It's alleged to be 1.90 grams, which makes the offense trafficking in cocaine a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in count 3? Or
Yes,
count
sir.
1? That was count 1.
Yes, sir.
Any questions about it?
No, sir.
Now, in count 3, what's alleged is on or about December 13th, 2024, in Willowick, Lake County, Ohio, that you did knowingly sell or offer to sell a fentanyl-related compound or some mixture, compound, preparation, or substance containing a fentanyl-related compound. The amount involved was less than 1 gram. It was 0.67 grams, which makes the offense trafficking in a fentanyl-related compound That is also a felony of the 5th degree. Do you understand what you're charged with in pleading guilty to in this count?
Yes, sir.
Any questions about that?
No, sir.
Now, there are 2 other charges in the indictment that are being dismissed pursuant to the agreement. Is that your understanding?
Yes, sir.
Any questions about those 2 charges?
No, sir.
All right, well then before I can accept your guilty plea to the 2 counts I just read to you, I need to make sure you understand all the rights you are giving up. And you first of all have a right to have a trial. That trial could be to me as a judge, or I listen to all the evidence and I would make the ultimate decision whether you're guilty or not guilty of each charge. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those jurors would consider and weigh all that evidence, and then those jurors would make the ultimate decision. And that ultimate decision reached by those jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty of each separate charge. You understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to have a trial in this case?
Yes, sir.
Now, if you had a trial, first of all, you'd have the right to have an attorney represent you at that trial. If you could not afford an attorney to represent you at trial, this court would appoint one for you free of charge to do that. Do you understand that?
Yes, sir.
Now, at a trial, the prosecutor here would be representing the state of Ohio, and he would have what we refer to as the burden of proof. Now, with him having the burden of proof, what that actually means is that it's his job, or he bears the responsibility or the obligation to prove you guilty at a trial before you could ever be found guilty. You're presumed innocent of these charges. The presumption of innocence sticks with you and stays with you until the state, if at all, was ever able at a trial to overcome that presumption of innocence and prove you guilty. Do you understand that?
Yes, sir.
Now, when we speak about this burden of proof, since this is a criminal case, that burden is what we call proof beyond a reasonable doubt. And that is the highest burden there is in our justice system. What it means, it's the amount of the evidence and the quality of that evidence that the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charges beyond any reasonable doubt before you could ever be found guilty at a trial of these charges. Do you understand that?
Yes, sir.
You understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
Now, in order to do that, or at least in order to try to do that, if we were going to have a trial, the prosecutor would be calling witnesses to come to court to testify for the state by answering questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right to ask those same persons questions on your behalf, and that's called cross-examination. He could ask them anything he wanted to within certain rules. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and to answer your lawyer's questions. Now, you don't have to do that, and you're not required to do that, but you have the right to do that if you want to. Do you understand that?
Yes, sir.
And you further can request this court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes, sir.
Do you realize you're giving up that right?
Yes, sir.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness, make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
Further, if we went to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge this guilty finding to a higher court, a court that sits above me. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, sir.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
Do you understand them all?
Yes, sir.
You still want to plead guilty?
Yes, sir.
You understand a guilty plea is a complete admission of guilt, so it means you'll be admitting to the facts being alleged by the prosecutor in regards to these 2 counts. We're not going to argue later that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is that you'll be, first of all, found guilty by the court, and then you'll subsequently, on a future day, be sentenced by the court. Do you understand that?
Yes, sir.
Now, as far as sentencing goes, both of these counts you're pleading guilty to are felonies of the 5th degree. Each of these are punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, sir.
Now, since there are 2 separate offenses here occurring on separate dates, separate acts, if I imposed a prison sentence, I'd impose it on each count. And as the judge, I would then have the discretion to run those prison terms concurrent or consecutive to each other. Concurrent means together. You serve them at the same time, together. Consecutive is one after the other. You'd serve the prison term for count 1 first, whatever it is, finish that, then you'd serve the prison term for the second count. You understand the difference there?
Yes, sir.
So in this particular case, if I imposed a maximum sentence of 12 months on each count and I ran those terms consecutive, you're looking at a maximum prison sentence in this case of 24 months or 2 years in prison. Do you understand that?
Yes.
Now, you currently have probation or parole or any type of supervision of any other courts or agencies?
No, sir.
Do you have any other charges pending against you right now?
No, sir.
Oh, nothing pending right now? I thought there was.
Oh, yeah, yeah.
There's
sir.
no formal charges, Your Honor. I believe that's accurate to say.
That was a bind over? Is that the case?
It was bound
It
over.
was bound
Well,
over.
then there's charges.
Forgive me, Your Honor. There's no formal indictment, yes, yet the charges are
He was
pending.
charged in one of the municipal courts,
Yes, Judge.
waived a prelim or had a prelim, and got bound over to the here.
Correct, Your Honor. My apologies, yes.
Anywhere else?
No, sir.
The only reason I ask that if there's other cases and you're sentenced to prison in that other case prior to being sentenced in this case, doesn't sound like that would happen here, but just because of the timing, if that even comes to fruition. But if you were, I could run a prison sentence, in this case concurrent or consecutive to that. So if you're serving a prison sentence at the time you come before the court for sentencing, and I impose a prison term, I can run a concurrent or consecutive to that case. I can't do it to some future unknown possible case. It's got to be already imposed for me to be able to do that. Do you understand that?
Yes, sir.
All right. Now, if a prison sentence is imposed in this case upon your release from prison, you could be placed on what's called post-release control, sometimes referred to as parole. That is a period of supervision you would be on after you served and completed the prison sentence. In this particular case, it could be up to 2 years. Do you understand that?
Yes, sir.
And if you are on post-release control and you violated any of the conditions of your supervision, we would have a hearing, or we wouldn't have a hearing, excuse me, the parole authority would have a hearing to see if you were in violation of your parole. And if they found that you were, they could send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall sanction of up to 9 months. Do you understand that?
Yes, sir.
Now, aside from the possible prison sentence here, there are other sanctions that could be ordered. You could be fined up to $2,500 on each count, so total maximum fine of $5,000. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yes, sir.
There's also a possible driver's license suspension that could be ordered of up to 5 years. Do you understand that?
Yes, sir.
Now, a few moments ago, I explained the possible prison sentence. I used the word possible because prison's not required with these charges. You are eligible for probation, or what we refer to as community control sanctions. Do you understand that?
Yes, sir.
Now, do you understand that just because you're eligible doesn't mean you would automatically be put on probation? It means I'll consider that if that's what you're asking for. I'm going to look at all the information presented to the court. Then I'll make the decision I think is the right thing to do. You understand that?
Yes, sir.
Now, if you are put on community control sanctions, it could be up to 5 years. As the judge, I have the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions of probation can be in order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. Do you understand that?
Yes, sir.
Further, if you're on probation and you were violating any of the conditions of your probation, we would have a hearing to see if you're what we call a probation violator. If it was determined that you were, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, including local jail time, or I could terminate your probation and send you to prison. If I did it then, again, it could be 6 to 12 months on each count. That could be consecutive, so up to a total of 2 years in prison, which could be consecutive to any other sentence you're serving at that time or you may be getting sentenced to at that time. Do you understand that?
Yes, sir.
Lastly, when we do come back here for sentencing, you're going to have the right on that day to say anything you want. Anything you'd like me to know or consider. Your lawyer could speak on your behalf. He can recommend a sentence to the court. The prosecutor could also recommend a sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever the lawyers have to say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation, and I don't have to go along and follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, sir.
All right. All right, well, do you have any questions for me regarding these potential penalties you face by pleading guilty to these 2 charges?
No, sir.
You understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
If you had enough time to go over this case with your lawyer, have him review the reports with you, discuss the issues, and answer whatever questions you may have?
Yes, sir.
Are you satisfied with the advice and counsel of your lawyer?
Yes, sir.
Has he, or has anyone for that matter, made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here today?
No, sir.
Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering your guilty plea freely and voluntarily?
Yes, sir.
All right, then. Do you have any questions for me at this time regarding anything we've just talked about? The rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions, Mr. Jones?
No, sir.
Do you need any more time to speak with your lawyer before we go forward with your actual plea?
No, sir.
All right, then what we're going to do at this point, prosecutor here is going to explain for me what he believes the evidence would show if we had a trial. I want you to listen to him, what he says, because I'll have some questions for you about that, all right?
Okay.
So, Mr. Geigerich, regarding the 2 that we're here for today, the 2 transactions.
Thank you, Your Honor. The evidence would show that the defendant came to the attention of and targeted by Lake County Narcotics Agency for trafficking of drugs. He was targeted by a confidential informant. The deal was set for December 10th of 2024 for $90 of crack cocaine. Deal was to occur at 6866 Center Street, City of Mentor, Lake County, Ohio, which is the Wendy's. The deal did in fact occur, and the suspected narcotics sent to Lake County Crime Lab were tested positive for cocaine, Schedule 2, an amount of 1.90 grams. He was again targeted on December 13, 2024 for $100 in crack cocaine. Deal was set. Deal was to occur at 30200 Lakeshore Boulevard in the city of Willowick, Lake County, Ohio. At the get-go, the deal did in fact occur, and the defendant added $100 in fentanyl at the buy. The CI did accept that, and the suspected narcotics were sent to the Lake County Crime Lab where tested positive for fentanyl in the amount of 0.67 grams. Thank you.
Thank you. So, Mr. Jones, were you able to hear what the prosecutor just had to say regarding what he believes the evidence would show if this went to trial?
Yes, sir.
What, if anything, do you have to say about those facts as he presented them? Are they true? Did you do what he said?
Yes, sir. It's true.
Very well, then, regarding count 1, charging with trafficking cocaine and felony of the 5th degree, what did you plead to that count?
Guilty.
Sorry?
Guilty,
I
sir.
thought you said not guilty, I'm sorry. In regards to count 3, charging you with trafficking and fentanyl-related compound, also a felony of the 5th degree, what is your plea to that?
Guilty, sir.
I have in front of me at this time, Mr. Jones, a 4-page document called a written plea of guilty and judgment entry, which sets forth everything we've just gone over. Before I can accept your plea, I need to make sure you understand this document and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes, sir.
Mr. Wolf, is that accurate? Did you review this with Mr. Jones, read it over to him, answer all his questions?
Yes, Your Honor.
When you did that, did he indicate an understanding of it to you?
Yes, Judge.
Is that correct, Mr. Jones?
Yes, sir.
So you understand what this document says?
Yes.
Do you have any questions for me about it?
No, sir.
Now, it also appears that you signed this document. Did you in fact sign it?
Yes, sir.
Mr. Wolf, you witnessed that?
Yes, Your Honor.
Mr. Geiger, you as well?
Yes, Your Honor.
All right, then at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect, the defendant was here in open court with his lawyer. Advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of this guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, trafficking in cocaine, a felony of the 5th degree in violation of 2925.03A1, as well as count 3, trafficking in a fentanyl-related compound, also a felony of the 5th degree in violation of 2925.03A1. Counts 2 and 4 will get dismissed at sentencing, but I'm going to defer sentencing at this time. I'm going to order a pre-sentence report investigation and drug and alcohol evaluation. I'll continue defendant's bond at this point at his own recognizance. So what all this means, Mr. Jones, first off, in regards to bond, I'm continuing your bond, so there's nothing more you need to do about that except to comply with the conditions of your bond. One of those conditions is that you don't use any drugs while you're on bond. You have to submit urine samples if requested. They have to be negative for drugs. If they're positive, a warrant would be issued for your arrest and your bond would be revoked. You understand that?
Yes, sir.
Now, also in regards to the OR bond, any bond you have to show up for court at your next court date, but if you're released on an OR bond, I think I advised you this when you were here last time, you have to show up at all future court dates. If you don't, that's a separate felony you could be prosecuted for, separate and apart from these charges. So it's important to show up. The sentencing is going to be, when is that, Mr. Shadone?
July, 1 second, Your Honor.
14th.
14th, yes, sir, 2 o'clock.
So July 14th at 2 o'clock will be your next court date, so that's what you need to be here for next, okay?
Yes, sir.
Now, before that, you're going to have to go to the probation department. We'll talk about that now. You're going to leave here right now. You're going to go to the probation department. You're going to meet with them, fill out some initial paperwork, and get your dates to come back for an interview. So in order for them to be able to prepare these reports, they have to conduct an interview with you, some testing. It's important that when they meet with you that you're open and honest with them because they're going to check and verify everything you tell them.
Okay.
And if they learn you're misleading them in any way, they'll let me know, and I would obviously consider that at the time of sentencing. Also, in order for them to me to be even able to consider probation as an option, this report that I've just ordered has to be completed. And in order for that report to be completed, the interview with you has to take place. So it's important you show up on time, when scheduled, at the probation department for that interview, because if they can't interview you due to your lack of cooperation and not showing up when you're supposed to, they won't be able to prepare a report. And without a report, the law doesn't even allow me to consider probation as an option. You understand that?
Yes, sir.
All right. Mr. Wolf, anything else for the record?
No, Your Honor. Thank you.
Mr. Gyrich.
Nothing more, thank
All
you.
right, thank you both.
All rise. Mr. Jones, hang on 1 second.
Your Honor, before you today on State versus Cortez Hopper on two separate files, file 24 CR 015 and 24 CR 432. We're here today for a change of plea. It's anticipated by the state of Ohio that the defendant withdraws previously under pleas of not guilty and enter pleas of guilty to the indictments as charged. The state of Ohio anticipates joining in a joint recommendation to run both files concurrent for a mandatory 11 years of prison. Other than what's been spread upon the record, no threats or promises were made to this defendant to induce these pleas. Thank you.
Mr. Watson, does that sound accurate?
Thank you, Your Honor. May it please the court, that is my understanding of this morning's hearing. I've had a chance to fully pre-try this matter with the prosecutor. I believe full discovery has been provided. I've also had numerous conversations with Mr. Hopper, both last year as well as most recently over the past couple months. He has told me that he is prepared this morning to enter a change of plea as outlined. He understands that by doing so, he'll be waiving certain constitutional rights. No threats or promises have been made in order for him to do so. And, Your Honor, he is also prepared to waive any PSR and proceed straight to sentencing if the court would allow. Thank you, Your Honor.
Mr. Hopper, it's been represented to the court. Well, first of all, were you able to hear what the prosecutor and your lawyer just had to say?
Yes.
They indicated to the court it's your desire to withdraw your previous entered pleas of not guilty in each of these cases and plead guilty to the one charge in each case with two separate charges. Then waive a pre-sentence report and proceed straight to sentencing, where you'll be entering into a joint recommendation with the prosecutor's office on behalf of the state that a prison term of 11 years, the minimum 11 years, be imposed in 24 CR 015, and that to be run concurrent with whatever prison term the court imposes in the other case. Is that your understanding, the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes.
Well, before I can accept your plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as other possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you the questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes.
All right. Let's get started then. Give me 1 second. All right, how old are you, sir?
32.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
And before you came into court here this morning, have you had any drugs or alcohol of any kind?
No.
What about within the last 48 hours?
No.
Not even prescribed medication, nothing?
No.
Okay. Now, you would have been served with copies of these indictments in each of these cases around the beginning of last year of 2024. Do you remember getting the indictments at some point?
Yeah.
And at some point, did you have the chance to go over those?
Yes.
In 24 CR 432, you're charged with one count. What's alleged here is on or about December 21st, 2023 in Painesville Township, Lake County, Ohio, that you did knowingly manufacture or otherwise engage in a part of the production of crack cocaine, a Schedule II controlled substance. That conduct constitutes the offense of illegal manufacture of drugs, a felony of the second degree. Do you understand what you're charged with and pleading guilty to in regards to count 1 of this case?
Yes.
Any questions about it for me?
No.
Now, in case 24 CR 015, you're charged with one count, and what's alleged here and what you'll be admitting to is on or about December 21st, 2023 in Painesville Township, Lake County, Ohio, that you did knowingly obtain, possess, or use cocaine or some compound mixture, preparation, or substance containing cocaine. The amount equal or exceeded 100 grams. It was 195.33 grams, which makes the offense possession of cocaine a felony of the first degree. Felony of the first degree. Do you understand what you're charged with and pleading guilty to in regards to count one of this case?
Yes.
Any questions for me about the charge?
No.
Well, then before I can accept your plea of guilty to each of these charges, I need to make sure you understand all the rights you are giving up by pleading guilty. And these rights I'm going to go over, you have them for both cases. I'm only going to go over them once, but they apply to both cases. If there's anything that particularly applies to one case and not the other, I'll make sure I let you know that. Otherwise, everything applies to both cases. And in each of these two cases, you have the right to have a trial. And a trial could be to me as a judge, where I listen to the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens. Hang on one second. Given this one form that the aggregate minimum prison term would be 8 years and the maximum would be 11 years.
The aggregate minimum?
It's for the one case. It says the aggregate minimum prison would be 8. It's for the F2. Would be 8 years, and the maximum would be 11 years. Wouldn't the maximum be 12 years?
Yeah, it would be 12 years, I'm sorry.
All right, now, let me start over here. You have a right to have a trial in either of these cases. The trial could be me as a judge, where I listen to the evidence and I make the decision. But you also have a constitutional right to a jury trial, which would be in front of 12 citizens from Lake County who would listen to the evidence and make the decision whether you're guilty or not guilty of each of the charges. You understand that?
Yes.
Now, in regards to a jury trial, if you had a jury trial, in order to be found guilty, all 12 jurors would have to agree together unanimously whether you were guilty or not guilty. A verdict in a jury trial must be unanimous. All 12 jurors have to agree either guilty, or all 12 have to agree not guilty. You understand by pleading guilty, you're giving up your right to the jury trial?
Yes.
Now, if we had a trial, the prosecutor here would represent the state. He would have what we refer to as the burden of proof. With him having the burden of proof, what that actually means is that it is his job, or he bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You are presumed innocent of these charges, and that presumption of innocence sticks with you and stays with you until the state, if at all, was ever able to overcome that presumption and prove you guilty. Do you understand that?
Yes.
Now, in regards to this burden of proof, since this is a criminal case, the burden of proof is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. What it means, it's the amount of the evidence and the quality of that evidence the state has to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of these charges beyond any reasonable doubt before you could ever be found guilty of any of these charges. Do you understand that?
Yes.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes.
Now, in order to try to do that, if we did have a trial in this case, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right to ask those same persons questions on your behalf. That's called cross-examination. He could ask them anything he wanted to within certain rules. Do you understand that?
Yes.
Do you understand by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right, at a trial, you can call your own witnesses to come into court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that, you're not required to do that, but you have the right to do that if you want to. Do you understand that?
Yes.
And you further can request this court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes.
Do you realize you're giving up that right?
Yes.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but more importantly, the prosecutor is not allowed to call you as a witness and make you get up on the stand and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
Further understand that if we do go to trial or did go to trial and you were found guilty, you'd have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No.
You understand them all?
Yes.
Do you still want to plead guilty?
Yes.
You understand a guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court and then you will subsequently be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, in case 24 CR 432, that's the illegal manufacture of drug case, that is a felony of the second degree. This offense is punishable by a mandatory prison term of an indefinite. This is going to be an indefinite mandatory prison term. Indefinite means there's going to be a minimum and a maximum. The minimum sentence is chosen from the range of 2 to 8 years. So as the judge, I'll select one of those numbers, 2, 3, 4, 5, 6, 7, or 8, and that will be the minimum sentence you'd have to serve. The maximum sentence is then determined by the mathematical formula. You take half of whatever the minimum sentence is and add it to the minimum, that becomes the maximum. So for an example, if I impose 2 years as the minimum, half of 2 is 1, and I add the 1 to the 2, and it becomes 3 years as your maximum. Another example, if I chose 6 years as the minimum, half of that is 3, I'd add the 3 to the 6, that makes 9, so your maximum is 9, so it'll be 6 to 9 years. And likewise, if the maximum sentence was imposed of 8 years, half of that is 4, I'd add the 4 to the 8, so your maximum becomes 12 years, so it'll be 8 to 12. You understand all that?
Yes.
So in this particular case, the maximum sentence you face is a mandatory indefinite prison term of a minimum of 8 years, a maximum of 12 years. Any questions about that?
No.
Now, in case 24 CR 015, that is a felony of the first degree, and due to the amount of drugs that are involved, you're considered a major drug offender, and this requires that a mandatory maximum sentence be imposed, which is an indefinite prison term of a minimum of 11 years, maximum of 16 and a half years. Do you understand that?
Yes.
Now, since there are 2 separate cases here, each requiring a mandatory prison term, I'll impose a mandatory prison term in each case, and as the judge, I have the discretion to run those prison terms concurrent or consecutive. Concurrent means you'd serve them at the same time together. Consecutive means one after the other. You understand the difference there?
Yes.
Now, just because each one is mandatory That doesn't mean they have to be served consecutive. I do have the discretion to run those concurrent with each other. You understand that?
Yes.
And that's what the joint recommendation is. You understand that?
Yes.
Now, as I indicated, each of these charges require an indefinite prison term be imposed, which means that there'll be a minimum sentence and a maximum sentence. And I need to advise you that in regards to that, there is a presumption that you will be released after you have served whatever the minimum sentence is that I agreed to, which is the minimum is 11 years. There's a presumption you will be released at that point. Now, that presumption can be overcome by the Department of Rehabilitation and Corrections. I have no say in that. But if they believe while you're serving your prison sentence that you're misbehaving, you're not following the institution rules, you're not sufficiently rehabilitated, you pose a threat to the community, if anything like that were to occur, they would schedule a hearing and argue that you should not be released at the minimum time. They should serve more time. You have a right to be at that hearing as well and present whatever you want them to consider. Then it's up to the parole authority to determine whether they're going to let you out at that point or make you serve more time. If they make you serve more time, they will then pick a new date which you should be released, and there'll be a presumption that you'll be released on that date. And again, unless you've misbehaved or not followed the rules, not rehabilitated, you have to be released at that point. They could continue doing that until the maximum sentence has been served. However, at the end of the maximum sentence, if you're still there, they have to release you. Even if you misbehaved the whole time you were there, they'd have to release you at the end of the maximum sentence. You understand that?
Yes.
Now, I do need to further advise you that since each case carries with it a mandatory prison term, the prison term imposed by the court will be mandatory, which means you will not be eligible to earn prison credit while you are in serving your sentence. Do you understand that?
Yes.
You are also not eligible for judicial release, which is a request of the court to let you out early and be put on probation. You're not eligible for that while you're serving any mandatory prison sentence. Do you understand that?
Yes.
All right. Now, are you currently on probation anywhere else, or any supervision, parole, anything like that?
No.
Do you have any other charges pending against you anywhere?
No.
Now, in this case, upon your release from prison, you will be placed on post-release control. It's sometimes referred to as parole. In case 424-432, that is the illegal manufacture of drugs case. Post-release control is mandatory for a minimum of 18 months up to possibly 3 years. In the other case, the possession of cocaine charge, post-release control is mandatory for at least 2 years up to 5 years. Do you understand that?
Yes.
And when you're on post-release control, if you ever violate any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each separate violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes.
Now, in addition to the mandatory prison terms that I've just explained, there's other sanctions that could be ordered. There's mandatory fines which are required to be imposed. In case 24 CR 432, the illegal manufacture of drugs, a fine of at least $7,500 must be imposed, and they could fine you up to $15,000. In case 24 CR 015, the possession of cocaine, there's a mandatory fine of at least $10,000 that must be imposed, and you could be fined up to $20,000. So with both cases, a fine of at least $17,500 will be imposed, and you could be fined up to $35,000. You understand that?
Yes.
Now, if you were to file an affidavit of indigency, which your attorney has represented the court, he intends on having you sign. He mentioned that in chambers to me. indicating that you're indigent, the court is permitted to waive those fines and not impose those. You understand that?
Yes.
Now, in addition to the fine I just mentioned, you could also be ordered to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes.
You could also suspend your driver's license for up to 5 years. Do you understand that?
Yes.
It's also been represented, I believe there's a agreement that you're gonna forfeit any contraband or instrumentalities that were seized at the time of the arrest in this case, which includes any drugs that were seized, any cell phones, and $469 in U.S. currency. You understand that?
Yes.
All right, now, a few moments ago, I explained the prison term the court's required to impose. I told you it was a mandatory prison term in each case, which means you are not eligible for probation or judicial release. The court will have to impose a prison sentence, and you'll have to serve whatever that term is. You understand that?
Yes.
Lastly, when we do proceed to sentencing, you're going to have the right at that time to say anything you want, anything you'd like me to know or consider. Your lawyer can speak on your behalf. He can recommend a sentence to the court. The prosecutor is also allowed to recommend a sentence to the court. Do you understand that?
Yes.
Do you understand that whatever anyone says at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I'm not required to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes.
All right, well, do you have any questions at all regarding potential penalties you face by pleading guilty?
No.
You understand all the possible consequences?
Yes.
You still want to plead guilty?
Yes.
Have you had enough time to talk about this case with your lawyer and have him go over everything with you and answer all your questions?
Yes.
Has he or anyone else made any promises to you about what exactly is going to happen at sentencing, which is inducing you to plead guilty?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering the plea freely and voluntarily?
Yes.
All right, then, do you have any questions for me at this time regarding anything we've just talked about? What you're pleading to, the rights you're giving up, the penalties you face, anything?
No.
Do you need any more time to talk with your lawyer before we go forward with your plea?
No.
All right, then what's going to happen at this time, the prosecutor is going to explain for me what he believes the evidence would show in each of these cases. We'll do one at a time. I need you to listen to him because then I'll have some follow-up questions for you. So on whatever case you want to go for first, but let's just do one at a time.
Okay, Your Honor. I think it's gonna go in chronological order.
Okay.
Okay. Your Honor, the evidence would show that on December 21st, 2023, Lake County Narcotics was advised of several individuals currently manufacturing crack cocaine inside a residence at 61 Fairgrounds Road in the city of Paynesville, Lake County, Ohio. This individual advised Lake County Narcotics when the individuals were leaving the residence, at which time the defendant was driving a vehicle which was stopped for subject to a traffic stop for expired registration. Driver was the defendant, front passenger was Taya Johnson, and the rear passenger was Prince Landers. They all were arrested on warrants. A search of the vehicle was conducted by Lake County Sheriff's and Lake County Narcotics Agency. A Purple Crown Royal bag was located inside the window control panel on the front driver's side. Multiple clear baggies of white powder were inside the Crown Royal bag. The search of the defendant yielded 4 cell phones and a large sum of U.S. currency, being $469.41. These items were sent to the Lake County Crime Lab, where it tested positive for cocaine amount of 195.33 grams, cocaine Schedule 2, and 8.77 grams of teneptapine, which is a Schedule 1 item. I mentioned that because that'll be forfeited. Upon the traffic stop, Lake County Narcotics proceeded to the residence at 61 Fairgrounds Road. They met with the CI, recovered a glass cup and scale with residue from the kitchen of the residence. They also were provided a video of the individuals manufacturing the crack cocaine. In the video, the defendant is using a glass measuring cup with cocaine, baking soda, and a microwave. Thank you. Nothing further.
Mr. Hopper, were you able to hear what the prosecutor had to say regarding what he believes the evidence would show in case number 24 CR 432? What, if anything,
Yes.
did he say about those facts he presented them? Are they true? Did you do what he said?
Yes.
Very well, then regarding count 1, charging you with illegal manufacture of drugs, a felony of the 2nd degree, what is your plea to that count?
Guilty.
All right, Mr. Geigerich, now is for 24 CR 015.
That was basically all the facts, Your Honor.
Oh, for both of them.
Yeah.
That's right. Never mind. There's nothing else that needs to be stated then.
No.
So in regards to case 24 CR 015, the charge of possession of cocaine, a felony of the 1st degree, what is your plea to that count?
Guilty.
All right, I have in my possession at this time, Mr. Hopper, 2 documents. They're both called a written plea of guilty and judgment entry, which sets forth everything we've just talked about. There's one for each case. Before I can accept your plea, I need to make sure you understand what it says in these documents and that you sign them here in open court. Now, my understanding is before I came out here, you had a chance to go through these documents with your lawyer. Is that correct?
Yes.
Mr. Watson, is that accurate? Did you review these with Mr. Hopper, both of them?
Yes, Your Honor. I went over each separate written plea of guilty form with my client. I read it to him, explained it to him. He read along with me, indicated he understood it. He signed it in my presence, and I signed it in the presence of the prosecutor, Your Honor.
Is that correct? Is there something you want to say?
You were going to ask me if that's correct, right?
No, I'm going to ask him first.
Oh, I'm sorry.
Mr. Hopper, is that accurate? Did you review that with your lawyer and have to go over it all with you?
Yes.
Do you understand what it says?
Yes.
Do you have any questions for me about what it says?
No.
Now, it also appears here that you signed these documents and your lawyer indicated you signed them. Did you in fact sign both of them?
Yes.
And you witnessed that also, Mr. Geigerich? Both of them?
I did, Your Honor.
All right, at this time, the court will accept the defendant's oral and written pleas of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charges, the effect of the guilty pleas, as well as the maximum penalties that can be imposed. Finding all of this to be knowing, intelligent, and voluntary, the court will accept the defendant's pleas, find the defendant guilty in case 24 CR 432 of count 1, illegal manufacture of drugs, the felony of the 2nd degree in violation of 29-2504, as well as count 1 in case 24 CR 015, possession of cocaine, a felony of the 1st degree, violation of 29-25.03A1 or A2. Hang on, make sure of that. That's possession of cocaine, 29-25-11 of the revised code. I think that's everything for the plea. Mr. Geigerich, anything I omitted or you want to address?
No, Your Honor.
Okay. Mr. Watson? We've
Nothing
covered
with regards
everything?
to the
Everything's
plea.
okay. Any reason then, Mr. Watson, not to go forward with sentencing at this time?
No, Your Honor.
Is there anything you'd like to say on behalf of your client?
Thank you, Your Honor. May it please the court, I'm going to be brief. Mr. Hopper is still a young man, obviously made some very poor choices. I know these charges are extremely serious. Mr. Hopper, last year, when I met him, had indicated that he wanted to do a change of plea, and I know he failed to show up, and there's no excuse for it, Your Honor. Mr. Hopper currently has 4 children. While he was out on the run, there is now a 5th child on the way. When Mr. Hopper was picked up, I met with him, and once again he had indicated to me that he wanted to take responsibility for his actions. He's got a plan, Your Honor. I know this is a lot of time hanging over his head. Regardless if the court were to impose the joint recommendation, which I hope the court will consider, but regardless, this is a lot of time that he faces, and Mr. Hopper has expressed to me that he plans on using that time wisely. He has a desire to get a barber license, possibly a CDL. He's learned that there's various programs depending on which institution he goes to. And ultimately, Your Honor, when he serves his time, he wants to get out and still be a father to his kids. Some of them will still be, young enough where he's going to plan on taking care of them, go to ball games, and be a dad. Your Honor, I know there's simply no excuse for the charges that he's facing. I'm not here to make them. Mr. Hopper's not going to be making excuses, but I am respectfully asking the court to consider imposing the joint recommendation. And like I said, Mr. Hopper plans on using his time wisely while he's incarcerated. Thank you, Your Honor.
Thank you. Mr. Hopper, you have the right to address, address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yeah. Basically everything he said. Some responsibilities as a man and everything I did, I admit to it. And I want to take this time wisely and get my life together so I can get back home to my kids and my family.
Thank you, sir. Mr. Watson, anything else?
Nothing further, Your Honor.
Mr. Geiger for the State of Ohio.
Thank you, Your Honor. In light, as the State of Ohio, as the court heard the facts, you see that they're very close in time and almost interrelated to each other. The State of Ohio believes that the 11-year sentence is appropriate and would ask you to honor the joint agreement. Thank you.
So you recommended each case be served concurrent to each other?
Yes.
Well, this court has considered the facts and circumstances of each case, the facts as they were presented to the court, the nature of the charges involved here, history of these cases. I've considered what's been said here in court by Mr. Watson, prosecutor, the joint recommendation. I've also considered what Mr. Hopper's statement. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 2911. I've also considered the factors in 2912. As for the no special findings in the seriousness factors or the recidivism factors, the court finds the defendant does have a history of criminal convictions. He was previously served a prison term. He violated his bond in failing to appear for his court dates and was gone for a substantial period of time before being arrested. Those are all factors indicating recidivism is more likely. Nothing makes it less likely. Each of these cases the court finds carries a mandatory prison term as noted previously. Prison is consistent with the purposes and principles of sentencing, and the defendant is not amenable to any available community control sanctions. Therefore, it will be the sentence of this court that in case 24 CR 015, defendants serve a mandatory indefinite prison term of a minimum of 11 years, maximum of 16 and a half years. It's the only option available for the court. Defendant is given credit in this particular case for 83 days that he's already served. Need to advise you that in this case, upon your release from prison, you'll be placed on post-release control for a minimum of 2 years, up to possibly 5 years. It's mandatory. While on post-release control, if you violate any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The court will also order a mandatory fine, the minimum mandatory fine of $10,000. I will waive that fine if an affidavit of indigency is filed, which I understand will be forthcoming here shortly. So if that's filed, that will be waived. At this point, it's imposed until that's filed. Defense order to pay all costs. I will order the voluntary forfeiture of the currency, the phones, and the drugs and paraphernalia. As for case 24 CR 432, as a sentence of this court, defendant served a mandatory indefinite prison term of a minimum of 4 years, maximum of 6 years. He has credit for 77 days in this case. I will run this prison term concurrent with the prison term imposed in 24 CR 015, as jointly recommended by both parties. Make sure the entries in each case reflect that the court did adopt a joint recommendation imposed by the court. The court adopted the joint recommendation recommended by the parties here. That was the sentence that was imposed. I'll order the mandatory fine in this case of $7,500. That's the minimum. Again, I will indicate that will be waived if an affidavit of indigency is filed. I need to advise you in this case, post-release control is mandatory for a minimum of 18 months. It could be imposed up to 3 years. Again, when on post-release control, if you violate any of their rules or conditions, the parole authority can send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I've just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Depends where the penalty costs in this action as well. Further need to advise you, I mentioned this during the plea, but I have to tell you again now at this point, since you've been sentenced to indefinite prison term for each case, which is a felony, there is a rebuttable presumption that you will be released from the service of the sentence at the expiration of the minimum prison term of 11 years. The Department of Rehabilitation and Correction may rebut this presumption and keep you in longer if at a hearing they make a specific determination regarding your conduct while you were in prison, your rehabilitation, any threat that you may pose to society. If they find that any of that exists, they cannot release you at the minimum and keep you into a longer date. They will then pick a future date to release you where there will be a presumption that you'll be released at that time. Again, the same procedure would follow. You'd have to be released at that point unless you've continued to misbehave, continue to pose a threat to society, haven't been sufficiently rehabilitated. Under no circumstances, however, can you be kept in beyond the expiration of the maximum sentence of 16.5 years, regardless of your conduct in prison. I think that covers everything. Is there anything that's been omitted or needs to be addressed, Mr. Geigerich?
No, Your Honor, thank you.
Mr. Watson, anything else for the record?
Nothing further, Your Honor.
All right.
All right.